Hello, everyone, and welcome to another episode of the Divorce Coaching Podcast with myself, Tom Nash, Mr. Divorce Coach, and my fellow colleague, Fay I. Hi, Fay.
Hi, Tom. It's great to be here again.
We have another exciting guest for you all today. We have Corinne Parke from Child and Child, a family law partner. I believe, Corinne, would you like to say hello, introduce yourself?
Hi, everyone. Thank you for inviting me. It's great to be here. So yes, I'm a partner at Child and Child in the family law team. Have been at Child and Child for about nearly 4 months now. So time flies and very busy.
Oh, it's really nice to have you, Corinne. And before we get into the nitty-gritty of educating our listeners and our viewers, I just want to because obviously it's the first time that I've really met you. It's great to see you, Corinne. And I just want to ask you, what made you want to specialise in family law? Was there something that clicked, or is it something you've always wanted to do?
So I fell into family law by complete mistake when I was a trainee back in 2002. Again, time flies. I was going to be this high-flying corporate lawyer, and then as a trainee was asked to do a family seat, and have never looked back, really. I think it's the dealing with people, and every person has an individual story. No one case is the same as another, and it sounds very, very cliche, but kind of unfortunately, clients do come to me at probably one of the worst points in their lives, and I like to think that by the time that they leave me, they kind of see the light at the end of the tunnel as such, and know where their story is going from there. Yeah.
Now, I know you, Corinne, anyway, because you and I are in the same resolution pod, so I've got a bit of a head start on Fay. We've been doing a little bit of a run on episodes recently on dispelling divorce myths and trying to bring some truth, some facts, and some knowledge to the world. So today we was going to pick your very, very bright brains around dispute resolution. So my first one is, what's dispute resolution?
So dispute resolution is kind of a whole umbrella term that covers any way that we can resolve a disagreement, whether that's through courts, but we're trying to avoid that at the moment, through negotiation, mediation, any kind of form of getting the parties to discuss things in a more collaborative, more amicable fashion, and dealing with it in a way that's more focused on them. They keep control of the matter in much more of a flexible way than if you do rely on the courts and their decisions.
Because I know there's various different terms, isn't there? So I've come across, in my time as a divorce coach, I've come across loads. So you get dispute resolution, you have ADR, so alternative dispute resolution, and I've even had NCDR, Non-Court Dispute Resolution. So I'm just trying to give everybody else a bit of knowledge there. So if they're going, oh, what's dispute resolution? But I've heard about this other thing.
So yeah, I mean, ADR and is kind of again, it's a very similar term to dispute resolution, and kind of can be used one or the other, really. A lot of people also refer to arbitration. But that's a type of dispute resolution and another option available to clients.
Yeah.
So I'm guessing that, people just kind of at the first stages of separation divorce, all of these kind of initials and things like that can be quite confusing. It isn't actually, the myth being this is scary, this is confusing. It actually isn't.
Absolutely. So, I mean, when clients come to me initially, some people really know what they want and how they want to go about it. And majority of them say, I don't want to go to court. I don't want to go through the stress, the time, the cost of pursuing it through courts, and what other options are available to me. A lot of clients do know about mediation, which I think is kind of the one that has been in the news, and you see it on television and wherever, where the other alternatives such as collaborative law, which Tom and I are involved in, and arbitration, and more of private dispute resolution, where you get experts involved but not the courts, they're not so involved with and not so knowledgeable about the options available to them. So as a solicitor, when you first come and meet a client, that's one of our jobs, is to make sure that the clients are fully informed about what's out there, what's available. There is certainly no obligation on anyone to set foot inside a courtroom, and there's no need to. And there's certainly so many options out there. And it's just trying to get that message across.
I think that is one of the biggest myths, though, isn't it? In terms of the clients that we all seek to support and serve, is that very first big scary question for most people is, am I going to end up in court? Or do I have to go to court? As well. So I think that's like the biggest myth that needs to be dispelled, that there's various options, as you say, that you've mentioned there, that people could look at. I want to pick one of them just for a minute, if I can. Arbitration. So again, this is another word that some people maybe have never come across in their normal daily routines and lives. I hear it every day. But again, as an alternative to dispelling that myth of having to go to court, could you explain a little bit about arbitration?
So arbitration with family, it's quite a new concept, because they used to just be mediation and court. But arbitration is more where, so both parties would tend to have solicitors representing them. And you would jointly instruct an independent arbitrator. So similar to a judge, but not in the court system. And you would arrange to have maybe multiple meetings with this arbitrator for them to kind of guide you and in some ways help you reach an agreement about whatever issue it may be. It can cover children, it could cover finances, it could cover perhaps cohabitees that are arguing about what property interest they may have. But it's an enforceable agreement once it's made. But again, it's a lot quicker. I mean, the court system at the moment, an application that's made, I think you're probably looking at the summer before you even get into court. Whereas if you were to go through arbitration, you could be resolved in a matter of 2-3 months at the most, which has the huge benefit of costs, of time, of stress, and obviously the family and that family impact that it has going through such long proceedings. It's a huge benefit to everybody.
Oh, that's brilliant, Corinne. So what I'm hearing you saying is this whole kind of umbrella term that you've talked about of dispute resolution covers so many things. And I'm guessing from what you're saying is that, you know, clients come to you and you're giving them a tailor-made package of support and help and advice depending on what they need. Exactly.
So I would be wrong to say that every case is suitable for mediation or suitable for collaborative or anything. There are some cases where you need to protect the client's interests, and the only way of doing that is through a court application. But they are the few. Most people, yes, mediation might not suit everybody, but there's normally an option out there that we can use rather than jump in with court proceedings.
So can you just let our listeners and watchers know what is collaborative resolution as opposed to any of the others?
Okay, so collaborative law is something that initially came over from America. As a collaborative solicitor, I have done a period of training where you approach cases in a different way. It's very focused on what the family needs and what's best for the family as a whole. So in a standard meeting, if there is such a thing as a standard meeting, both parties would instruct solicitors who are collaboratively trained, and they enter into an agreement called a participation agreement that would set out kind of the goalposts and the conduct and the way that those meetings are going to go forward. So an acceptance that you both have to listen to each other, that you're doing this for the interests of perhaps the children, And also that you have no intention of referring this to the courts, because then that focuses both parties on what's best, rather than thinking, oh, well, if I don't agree with this, I'm just going to jump ship and go off to court. So then we have a series of meetings, however many are needed, to try and agree whatever issues we have, whether that's finances or children, or even if the parties need a divorce, what grounds those divorces are going to be on. And then throughout the course of the collaborative process, we can bring external people in. So people such as Tom can come in and help the parties deal with their family and how perhaps they're going to speak to the children and how they get through the divorce itself, through to financial experts with pensions perhaps, and how the pensions are going to be divided and how best each party can deal with things to get the best outcome for them, really.
It's also not adversarial, is it? Because
no,
being
very much
everyone's working together for the greater outcome.
Yeah,
which is cool. Okay, so one of the things I want to ask, I suppose, in terms of dispelling yet another myth, because people always worry about the costs of going to court. When you're talking about the time there, I mean, the courts already had a bit of a backlog, didn't they? Because just in terms of the sheer volume that they have to deal with, yet alone with the last 20 odd months of COVID, etc., and how that's had an impact. But in terms of when it comes to things like cost, because that can be a really important factor, whether it's a large pot of assets that is being divided or even a very small pot of assets, it's still ultimately important how that gets divided. So in terms of looking at dispute resolution options, is that more costly, or is it because you mentioned like a shorter period, let's say with arbitration, could you get through the process quicker and maybe more expensive or cheaper? But I mean, how would it work potentially?
It really depends on the type of dispute resolution that you're going to be involved with, for a start. So, for example, with mediation, that does tend to be cheaper because the solicitors don't tend to be quite so involved. So, for example, if I was to send a client off to mediation, yes, I will still be in the background, but they're not incurring my normal hourly fees along with that mediator. So they tend to find that mediation is cheaper. With things like arbitration and collaborative, it does tend to be that solicitors tend to spend a large amount of time over a short period doing that work, just because we're focused on those clients at the time.
Yeah.
So it may be that clients find that they're incurring quite substantial fees over a short period of time with that resolution. Whereas if you compare that to a court proceedings, where you may still be involved in proceedings over 9-12 months, if not more,
or longer, yeah,
exactly. And then maybe in some situations you don't incur those costs each month, but they would total a similar amount. The other benefit is that obviously with court proceedings, especially financial ones, and often now the children proceedings, there are lots of court hearings if you were to issue applications, and those court proceedings result in fees.
Yeah.
Whereas if you're going to go through the collaborative process or arbitration, it's 1, maybe 2 appointments, so that does reduce your costs. I do tell clients not to agree to a dispute resolution system just on the basis of cost. That's not why you're doing it. You're doing it for the good of the children, of the family as a whole, and yourself, your mental health, your stress levels, everything else. But it does tend to end up being slightly more cost effective.
Yeah, I think that's a lot of the conversations I have with clients as well. Sometimes is trying to weigh up the amount of impact it's going to have to you, both, as you say, stress and emotively, but how that impacts your own work productivity for the next 12 months. Absolutely. While you're going through this process. And actually, if there is an option to come to a resolution and a resolve much quicker, would you rather invest that time and that money now than trickling it over a period of time? And also anything else that could change along the way in between now and then.
Exactly.
So actually, I was going to ask you then, what advice would you give on the other side of the fence? What if you had a friend that came to you and said, "Oh, I'm going to go and talk to some solicitors. What questions should I ask when it comes to how do I stay out of court?" What would you advise someone to ask?
Oh, that's a tricky one. What questions would I ask?
Sorry.
Got me out there, Tom. I would ask them what kind of areas of expertise they have, because certainly, especially with things like collaborative law, then there are lots and lots of solicitors who are not trained in collaborative. Now, I'm not saying by any means that they're not excellent solicitors, but they wouldn't be able to lead them down that course of action if that's something that they're particularly interested in. You also probably want to know what experience your client, your solicitor would have in relation to dispute resolution. Do they encourage people to try and resolve things through other ways, or are they very litigious and say, no, the best course of action for you is definitely to issue a court proceedings without any hesitation, go jump straight in. For some people, that might be the way that they want to deal with it, but from my experience, most people don't. And you also, I mean, we've spoken about arbitration and mediation, but there are also things that solicitors can do themselves. So such as round table meetings. So that wouldn't involve any other parties necessarily other than the solicitors, but some solicitors feel very uncomfortable sitting around a table with their counterpart. Whereas I would relish the opportunity, because we then have the clients in the room along with the solicitors and the option to discuss things. And if we feel that there's need for a coach or a financial advisor, then we can bring you in. So the clients really need to know what their solicitors are happy to do. Some people don't feel comfortable with it, but you have to have a rapport with that client and that solicitor. It's very important to build that relationship from the start.
Yeah, absolutely. It's the same with coaches, and I always say to any clients, if they're starting out seeking any legal advice, is do some window shopping, speak to a few people, same as I do with clients that come to me for coaching. Go and speak to one or two other people, make sure you're happy with the person you're working with, especially as you said earlier, when you're in that space where you need to be operating from a place of strength, but ultimately you're in a place of weakness and despair, and you don't know what's going on. That to try and make those decisions, it's really important. It's paramount that you find the right person for you.
I find that the people need to. It's part of my job to ask them lots of probing questions and lots of personal questions. And if you don't feel comfortable with me or your solicitor, then I'm not the right person for you. Because in the end, for me to be able to get the best result, I need to ask those questions. So that relationship is essential.
Yeah, it's really nice to hear that, Corinne. And I know the experiences that I have with a lot of my client base, they are petrified of even speaking to a solicitor, because they're so frightened of things getting out of control or things going too far when they're not ready, they haven't made a decision. And I suppose I wanted to ask you, if you're kind of working in a person-centered and client way, are there opportunities for people to just say, let's hold, let's just take some breathing space and decide on our next steps, rather than things snowballing and they don't feel in control of what's going on?
Absolutely. And I do that all the time. It's really important that a client feels in the right frame of mind, in the right capacity to be able to make what are really, really important decisions. So if they don't feel that they're able to, for whatever reason, whether that's health or too many stresses at work, or it's just got too much and they need some breathing space, that's absolutely fine, whether they're in the middle of court proceedings or whether they're going through mediation. I often have clients that say, look, can I just have a breather for a couple of weeks and then I'll get back to you when I'm ready? That's absolutely fine. Look, in the end, the client is acting for you. We're acting in your best interest, whatever that may be. And if you're not in the position to give me the instructions and to kind of digest the advice I'm giving you, it won't work.
Is there a bias for where I must have said something because my phone just flashed at me? It thinks I just said Siri. It's trying to talk to me. There you go. Real life. This was live. Don't know where it thinks I said Siri. I was going to ask now. Is there a bias where dispute resolution is used predominantly for financial matters or child matters, or is it an equal footing?
I think it used to be biased towards children matters. Okay. Because of the kind of the family focus and being able to act in the children's best interests. But I think more and more, especially as the knowledge of the ADR and the alternatives that are available become more widespread, I think that finances and other issues are becoming a lot more open and a lot more able to be discussed through the alternative sources and forums that are available. The family lawyers as a whole is very much we're still in the infancy of trying to encourage people to look at alternatives. You still get some old timers, if I can call them that don't agree with it and don't see that it will work, but I would like to think that we're proving them wrong in some ways. Yeah,
I was going to say, well, just from an opinion poll piece of my own, I think that actually having those different options, as you said before, at the very beginning, no situation or couple or individual is the same. No. So it's about tailoring it to suit everybody and having a pure outlook of, no, it's going to be litigation, we're going to go straight to court and going to put these orders in, etc. That sometimes that contentiousness and animosity can actually be built out of how you approach the process. Yeah. Actually, where you could approach it differently through different forms, as you mentioned, could actually help lessen the impact on everybody involved.
Exactly. I mean, divorces, and whether it's divorce or separation or just an issue regarding the children, is such huge impact on everybody. The less angst and the less stress that there is in these matters, it helps everybody involved. It's going to be difficult, whatever, and I'm not trying to pretend it won't be, but if you can help it in some way and maybe kind of approach it from a different perspective and get other people involved that can help as well, it's all the better for everybody. It's a win-win.
Corinne, can I ask you, are there instances when dispute resolution or collaboration is not the right path to go down? And I'm thinking along the terms of domestic violence and abuse. When do you not use this type of resolution?
Yeah, so there are certainly some red flags as such that we would say that they're not suitable. Unfortunately, especially with COVID at the moment, there are a lot of domestic violence issues that are going on, not necessarily physical, but a lot of the mental abuse and controlling behaviour. I think one of the particular red flags for me is financial control. So, for example, if you have a husband who has taken complete control over all of the financial assets, the wife does not have any knowledge or any control as to what's going in and out of a bank account on a monthly basis. She has no idea as to what her husband earns, what she needs, all of that kind of thing, and he's very controlling as to what he gives her. It's going to be difficult because she's going to feel under a lot of stress and a lot of control, and I question whether she would then be in a position to make those decisions. Now, it may be that we can get some financial advice, and it may be possible, but I would certainly need to make sure that that's safe for her and that she's not under any stress before we go any further. Domestic violence is one of those things, unfortunately, that we do need to protect against. So in those circumstances, we may need to put some safeguards in place first, or the client may feel that they're just not happy with it, Or it may be that things like mediation might not be possible when they're going face to face with somebody on their own, but maybe more of a supportive environment like roundtable meetings, maybe. Again, you can kind of make something fit if it's suitable, but domestic violence is a real concern. That was a very long answer for a very short question.
Well, it needs a long answer. I mean, it's something that we always talk about because it's in the news at the moment. It's really important that we talk about it and we help people to know who to turn to, and that it's not scary to get advice from people like yourselves when you may be a little bit scared and frightened of the whole process. Yeah,
I mean, with domestic violence, sometimes we can help them with the original urgent issue. And then they need to go away, as we were just speaking, and take a couple of weeks, months to kind of digest the position they're in before they can go any further. It's not one of these things where it all has to be done at once. And I've had numerous clients where, yes, there was some urgent applications and issues that needed to be made to kind of protect their position. But a few months down the line, things have calmed down, and then we can look at alternatives rather than just jumping into court. Never say never, but obviously my clients' best interests and their welfare is my main concern.
Yeah, absolutely. There was also one last thing I was going to ask you. Because you can have private FDRs as well, can't you? Because I was asking earlier about balance of finance and children. So that's actually specifically for a financial dispute resolution, isn't it? Yes. So again, would that be calling in the financial experts as well, and do they deal with that, or is that something that the solicitor still manages?
So private FDRs are slightly different in that you tend to be halfway through a court application at that point.
Right. Okay.
So you've already issued your financial application, and mostly at the moment, due to the huge backlog in cases that are going through the courts, I have cases that are waiting 6-9 months for another court hearing. Yeah. Whereas you can arrange for what we call a private FDR, which is where you jointly instruct, they're normally barristers that are trained to adjudicate on that financial issue. And then you treat it very similar as you would a courtroom, and the solicitors and the clients would be present. They would put their cases to this adjudicator, who would guide them and trying to make an agreement and a decision. Nothing can be forced upon either party, so it's very similar to mediation in that way, but you do have that third party there kind of giving indications as to what is a realistic outcome. Private FDRs tend to be about avoiding the backlog through the court system.
Yeah.
And it does give a little bit more control about timing, costs, everything else. But it's you're already within the court system at that point in time.
Okay. How would that be? Let's put it one of my last questions, because I've asked loads. But how would that? Is there kind of an equivalent for child matters? Because as you said, and as we've all agreed, that the it's not, they can't help it. They're undersupported and underfinanced and understaffed. It's not the court's fault. They would rather have these things resolved sooner. That's a wider issue. We'll talk about politics another day. But from a child matter, a children matter, if you aren't able to get in for a court hearing for 6, 9, 12 months, and especially if it's really very young children as well, where actually then that sets precedent, and it could be really challenging for a lot of the work that I do with parents in terms of actually they haven't been able to be the parent they want to be, and that time's been restricted. So is there alternatives from let's say a child version of FDR? Could that be used?
Not really, unfortunately. Not so much. Courts do tend to encourage the parties to think about going to mediation, whether they're at the beginning or halfway through a court application. That's always an option. The children matters, the courts tend to be a lot more focused on getting urgent issues dealt with. So for example, Christmas coming up, if those issues needed to be dealt with, the courts will do everything they possibly can to get something listed. But there isn't that private hearing available as such. You would have to go either through the collaborative route or mediation, really. But again, that's not enforceable. That's nothing that can be forced upon somebody.
Again, they're both voluntary. You
Exactly.
can't, yeah, exactly. Okay. Well, you have answered a whole host of all of my questions.
Yeah,
anything else?
It's been amazing. The only, I suppose it'd be nice to round off with, I kind of want to know from you, Corinne, and get your kind of take on it. With, you know, this big umbrella of dispute resolution, have you seen more people wanting to do these sorts of resolutions? And do you think that's because people are wanting to focus on their mental health and well-being more? Do you think there's more awareness of it, that they're wanting to hear the child voice? What's your opinion on why so many more people are looking for a different resolution rather than going to court?
I think it's certainly becoming a lot more widespread, and the knowledge of people and the availability of these options is becoming more and more. I think clients need that information. And I think with what we've all been through over the last, nearly 2 years, our mental health and the well-being of the family as a whole has become a lot more at the forefront of everyone's minds. And I like to think that people don't want to go to court. It's not something that they necessarily want to go through and experience, but there are issues, sadly, that need to be dealt with one way or another. And I think the job of solicitors now is to get that knowledge and those options out there. Some people come in knowing exactly how they want to deal with something, and I want to go to mediation, or can you refer me to a collaborative lawyer? Whereas some have absolutely no idea where they're coming from, what they need to do, how we can help them. And that's our job, to be able to guide them in the right way and get the best outcome for them in the end.
Well, you've definitely dispelled some myths for us, and for anybody that's kind of watching.
There are lots more to come.
But yeah, for anyone that's watching and listening, no, you don't necessarily have to go to court, and there are various options. So come and find very helpful people like Corinne, very knowledgeable people that help you, give you different ideas and approaches. But yeah, I suppose actually in closing, I'm going to start doing this and be more cautious about doing this now. Do you have any questions for myself and Fay?
Ooh.
I caught both of you out there.
I'll ask both of you. What does the client expect most out of a solicitor? What do they really need from us, first of all?
Go on, Fay. What do you think?
I mean, the thing that sprung to mind is, I think the experience that I've had with clients, they want solicitors to give them the answers sometimes, and obviously sometimes that can't happen. I think there's sometimes an expectation over solicitors, but I think in all, they just want that support in making sure things go smoothly. And I think, to me, that's really important. And you know, I think more solicitors are getting on board into this more holistic, like you said, well-rounded, collaborative kind of approach and framework of support for people. So yeah, I think there's a big shift, isn't there, that's happening at the moment.
Absolutely, yeah.
I'd agree. I think in that first instance, that whether you were the one that decided it or whether it's become as a shock to you, and that first thing is, well, what do you do? And everybody's immediate go-to and answer is speak to a solicitor, and you go and speak to a family lawyer. And I think that especially a lot of people in those earlier days and those earlier moments, they're looking to you guys in your industry, in your sector, as Fay says, to have every single answer, whether it's legal, financial, child matters, emotional. They want all of that wrapped up in one. And I think that's also something that, again, reasons why we do this is to help re-educate people in terms of having that best support network around you. Is, yes, have the legal aspect with someone like yourself, but yes, also have the financial aspect. You're not an expert on tax and wouldn't be able to give them advice on capital.
I wish I was.
Exactly. much the same as it's not our job to help them fill out and complete formies and things like that. But likewise, it's also not the financial planners or the mortgage advisors' area of expertise to help them deal with their emotional well-being and how they're getting through this and how they're communicating with their ex. So I think it's around all of us in a support network of legal, emotional, financial, working together to support that client in one area. And one of the things that I really love, actually, that I've noticed with all the sisters that I know and have worked with over the last couple of years, you mentioned them earlier, the old guard, or the solicitor of yesteryear, should we say? That I have very rarely yet to meet any of those people. Every solicitor I've ever worked with or known and had interactions with, and they do this because they care. They do this because they want to help, and they want to create a better environment out of what is a challenging situation for anyone to go through. So I think if people come into their solicitors just knowing that actually that they also know, the solicitors, they have boundaries, they have a lane to stay in, which is a lot, because you guys have got a lot to do, but likewise there are other people that help you to be able to do your job better as well.
Absolutely.
With coaches, with financial planners, with IFAs, with therapists, so on and so forth, and all of us focusing together to help the individual client at the end of the day.
Absolutely, I couldn't agree more.
I think that's a great place to end. It's been amazing. It's been lovely to meet you, Corinne, and I hope we will meet again, whether you come back on for the podcast later on next year.
Oh yeah, we're doing a round 2. We'll have you back.
No, thank you. It's been really, really good, really enlightening.
Well, thank you very much for joining us. And as we always say to anybody that's watching or listening, if you've got a comment or a question, either add it somewhere in the comments below, wherever I'm pointing, or send it through directly to myself and Faye. And if you want to get in touch with Corinne, do let us know. Contact me directly through Instagram, LinkedIn, wherever, and I'll put you in touch. But thank you very much for being here today. It's been lovely, and thank you for dispelling a load of myths for us.
Thank you.
All right. Thank you. Bye.
Bye.